What you know, Alibiers. Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. It's Wednesday, January 15th. My internet took about an 18-hour nap yesterday, which is why I didn't get an episode up, but it came back on during the night and I'm ready to roll. I had planned to read through the last bit of the motions in the Corey Richens case, but there's a new filing in the Donna Adelson case where she's requesting a change of venue, and I thought we would go ahead and do this one first. So let's read through this filing. It was filed on Monday, January the 13th. It says Mrs. Adelson was arrested on November 13th, 2023, and on November 15th, 2023, she was indicted for first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. The trial in this case is scheduled to begin with jury selection on June 3rd, 2025. The undersigned counsel intended to attempt to pick a jury prior to raising this issue, and they cite Foster versus State. However, on December 31st, 2024, the clerk of court failed to seal the transcript of the September 6th, 2024 in-camera hearing on the defendant's motion in limine concerning the testimony of Mrs. Adelson's son. During that hearing, the court ruled that Dr. Rob Adelson's opinion was inadmissible. It is damaging enough that a son is called to testify against his mother. Now, with this information about his inadmissible opinion out there, no one can unring that bell. As a result of the clerk's violation of the court's order concerning sealing of the transcript, Mrs. Adelson has been forced to file this motion sooner. The next section is Statement of Facts. On July 18, 2014, Dan Markell was killed while sitting in his car in the garage of his Tallahassee home. Professor Markell was a prominent law professor at the FSU College of Law. Media coverage began almost immediately. The Tallahassee Police Department began an extensive investigation which involved the FBI and law enforcement officials in multiple jurisdictions. On July 17, 2015, the Tallahassee Police Department released new details in the investigation. On May 25, 2016, Sigfredo Garcia is arrested in the case. Although his report was initially sealed, it was unsealed on June 2, 2016. Those documents identified Rivera. Both Garcia and Rivera are indicted on June 17, 2016. Additionally, in June 2016, a draft probable cause affidavit identifying Catherine Magbanua, Charlie Adelson, and Donna Adelson is leaked to the media. On August 29, 2016, the state released the video of Wendy Adelson's Tallahassee Police Department interview. Garcia and Rivera separately demanded speedy trials, which are set for November 14, 2016 and October 24, 2016, respectively. On September 17, 2016, the investigation and prosecution of Garcia and Rivera are featured on 2020. In the footnotes, it has the case has also been featured on subsequent cable television programs, including Dateline, multiple times. After Rivera gave a proffer to the state, Catherine Magbanua is arrested on October 1st, 2016. On October 4th, 2016, Rivera pleaded guilty to second-degree murder, and he is sentenced to 19 years in prison, concurrent with his 12-year sentence in a federal RICO case. Since Rivera's plea, the case has been tried 3 times. Garcia was convicted during a joint trial with Magbanua in October 2019. Magbanua was retried and convicted in May 2022. Shortly before Magbanua's second trial, Charlie Adelson is arrested on April 21, 2022, and Charlie was convicted in November of 2023. 1 week after Charlie's conviction, Mrs. Adelson was arrested at the Miami International Airport. The media coverage throughout this investigation and trials is overwhelming. The trials have all been televised by local and national news. Additionally, the case is the focus of numerous podcasts and blogs. Guilty as charged. The undersigned counsel is retaining an expert to compile the pretrial publicity to present to this court in support of this motion. The next section is the argument. Mrs. Adelson has a fundamental right to a fair trial by an impartial jury. In essence, the United States Supreme Court has written, the right to a jury trial guarantees to the criminally accused a fair trial by a panel of impartial, indifferent jurors. The failure to accord an accused a fair hearing violates even the minimal standards of due process. And they cite Irwin versus Dowd, the 6th and 14th Amendments of the United States Constitution, and Article 1, Sections 9, 16, and 22 of the Florida Constitution guarantee a fair trial by an impartial jury. However, Mrs. Adelson cannot receive a fair trial by an impartial jury in Leon County. The pretrial publicity in this case has been so inflammatory, emotional, and pervasive that the Leon County jury pool is now tainted by preconceptions, bias, and prejudice towards Mrs. Adelson. The effects of this publicity make it impossible for a Leon County jury to render a fair verdict based solely on the evidence presented at trial. Unlike many of the trials in which a change of venue was denied, the pretrial publicity in this case includes traditional news, as well as blogs and podcasts produced by lawyers and laypersons. This is part of the reason why the court recently granted a change of venue for Brian Kohberger in Idaho. In the footnotes, they give a link for the September 6, 2024 order granting the defendant's motion for a change of venue for Kohberger. The next section, the nature and extent of pretrial publicity in this case warrants a change of venue to protect Mrs. Adelson's rights. The media coverage in this case warrants a change of venue. Not only has the pretrial publicity been extensive, but it's also been highly inflammatory and prejudicial to Mrs. Adelson. In assessing whether pretrial publicity requires a change of venue, the court must determine whether the general state of mind of the inhabitants of a community is so infected by knowledge of the incident and accompanying prejudice, bias, and preconceived opinions that jurors could not possibly put these matters out of their minds and try the case solely on the evidence presented in the courtroom. They cite Manning versus State and say, as the Florida Supreme Court has noted, every trial court in considering a motion for change of venue must liberally resolve in favor of the defendant any doubts as to the ability of the state to furnish a defendant a fair trial by a fair and impartial jury. Every reasonable precaution should be taken to preserve to a defendant trial by such a jury, and to this end, if there is reasonable basis shown for a change of venue, a motion therefore properly made should be granted. And they cite Singer versus State. To determine whether the community's exposure to pretrial publicity warrants a change of venue, the trial court may consider 1, inflammatory pretrial publicity, or 2, difficulty in securing an impartial jury. And they cite several different cases to support their argument. In reviewing a trial court's decision regarding venue, courts examine any indications in the totality of circumstances that petitioner's trial was not fundamentally fair. The United States Supreme Court and the Florida Supreme Court have considered the following factors in making such assessments: whether the reporting has been factual versus inflammatory or emotional, whether the publicity has included information that would be inadmissible at trial, the existence of pro-prosecution bias, the timing of the publicity relative to the incident and the trial, and the community's hostility towards the defendant. As discussed below, these factors warrant a change of venue in this case. The reporting in this case has been inflammatory, emotional, and inaccurate, which distinguishes it from the reporting straight facts in cases in which a change of venue was not required. Even when these stories report on newly released facts, they take information out of context and use inflammatory language so as to strongly suggest Mrs. Adelson's guilt. There has also been a tremendous amount of prejudicial and inflammatory editorializing in this case. In addition to including such prejudicial mischaracterizations, the pretrial publicity in this case now includes opinions about Mrs. Adelson that this court ruled were inadmissible at trial. As the United States Supreme Court decried in Shepard, the exclusion of such evidence in court is rendered meaningless when news media make it available to the public. For example, in a sealed hearing on September 6, 2024, the court ruled that Rob Adelson's opinion concerning his mother's guilt would be inadmissible. Since the clerk of court violated the court's order sealing the transcript of that hearing, and despite the fact that his opinion is inadmissible at trial, the Tallahassee Democrat, as well as a plethora of podcasters, have now published Robert Adelson's opinion. A copy of the article is attached and incorporated as Exhibit A. Look, to be fair, y'all, I didn't know it wasn't supposed to be out there, so I did the episode on it. My bad. Additionally, this is not a case in which the passage of time has dulled the effects of the pretrial publicity. The intense media focus on this case continues even today. There is no suggestion that the media will stop covering this case prior to trial. Rather, if the coverage of the 3 previous trials are any indication, it is likely that the jury selection and trial in this case will continue to attract huge media interest. Thus, this case is distinguishable from cases like Patton versus Yount, where jury selection for Yount's second trial occurred 4 years after the extensive publicity reached its peak. There is not such a gap in time during which potential Leon County jurors will be free from inflammatory and prejudicial media coverage. Were Miss Adelson to be tried in Leon County, the inflammatory publicity would be fresh in the jurors' minds. Aside from considering these individual factors, it is important to consider the particularly damaging effects of internet-based publicity in this case. Internet coverage of this case has contributed heavily to the community bias that will prevent Mrs. Adelson from receiving a fair trial by an impartial jury if she's tried in Leon County. Publicity on the internet is particularly harmful for several reasons. Perhaps of most concern is that the internet provides avenues for publication by those who may feel less bound by standards of accuracy, fairness, and objectiveness. See Lindsay Powell note, Getting Around Circumvention, a proposal for taking FECA online. And they quote, moreover, the internet lacks many of the mechanisms that promote accountability in the institutional media. Where journalist careers may be broken on ethics violations, bloggers are riding in the Wild West of cyberspace. There remains no code of ethics or even an employer to enforce any standard. The next section, the court should grant a change of venue now as opposed to waiting to attempt to seat a jury. They cite a case, I'm not even going to try to butcher that name, but it's in Louisiana. The United States Supreme Court emphasized that in the least most egregious cases of inflammatory pretrial publicity, it is not necessary to examine the jury voir dire to determine that a defendant's rights have been violated. In that case, the court overturned the defendant's murder conviction, holding the trial court's refusal to grant a change of venue constituted a denial of due process of law. The court noted that it made its determination that the defendant's constitutional rights had been violated without pausing to examine a particularized transcript of the voir dire examination of the members of the jury. Any effort to try Mrs. Adelson in Leon County could be but a hollow formality, given the pretrial publicity to which the Tallahassee community has been exposed. Thus, it is unnecessary to try to seat a jury before ruling on this motion. Even if this court attempted to seat a jury before granting a change of venue, voir dire may not be able to ferret out jury bias. On the effectiveness of voir dire in criminal cases with prejudicial pretrial publicity, an empirical study said, our study, however, along with a number of other studies, suggests that confidence in voir dire as an effective remedy for exposure to extensive, highly prejudicial pretrial publicity is not warranted. The Supreme Court has recognized the limitations of voir dire in highly publicized cases. For example, in Irvin versus Dowd, the United States Supreme Court discounted the claims that potential jurors made that they could be impartial, where so many times admitted prejudice, such as a statement of impartiality, can be given little weight. In his concurring opinion in Irvin, Justice Frankfurter explained the fundamental problem with relying on voir dire where there had been such intense pretrial publicity in the case. And they quote, "How can fallible men and women reach a disinterested verdict based exclusively on what they heard in court when, before they entered the jury box, their minds were saturated by press and radio for months preceding by matter designed to establish the guilt of the accused? A conviction so secured obviously constitutes a denial of due process of law in its most rudimentary conception." In subsequent cases, the court has reiterated that voir dire is not always sufficient to protect a defendant's constitutional rights. The atmosphere in Tallahassee created by the pretrial publicity in this case is sufficiently inflammatory and prejudiced toward Mrs. Adelson that voir dire would not ensure that she would be tried by an impartial jury. Thus, this court need not attempt to select a jury before granting a change of venue. The next section, granting a change of venue now, would promote the efficient use of resources. The sooner this court determines where to move this case, the sooner the court, the parties involved, and the county to which this case is moved can make necessary arrangements. Furthermore, not only would an attempt to seat a Tallahassee jury in this case be futile, it would be wasteful. At the least, an attempted jury selection in Leon County would cost money and delay the proceedings. However, as the Florida Supreme Court has recognized, the resource costs of improperly denying a change of venue motion can be far worse. And they quote Singer versus State, "A change of venue may sometimes inconvenience the state, yet we can see no way in which it can cause any real damage to it. On the other hand, granting a change of venue in a questionable case is certain to eliminate a possible error and to eliminate a costly retrial if it be determined that the venue should have been changed." The last section is the conclusion. Based on the above, as well as the expert research which will be presented to the court, Mrs. Adelson's right to a fair trial can only be ensured by changing the venue for the trial. Wherefore, the defendant, Donna S. Adelson, requests that this court grant this motion, change the venue for the trial in her case, and for such other and further relief as is just and proper. So there you go. We'll see what happens with that. I'll keep you posted if anything new is filed. Hope you guys have a good rest of your afternoon, and we will see you soon.